Good afternoon, everyone, and thank you for joining our webinar, Overcoming Form I-9 Challenges in Staffing. We know that everyone is extremely busy, and we appreciate your participation on this webinar. My name is Melissa Prentice. I am the Director of Sales and Marketing at I-9 Advantage, and I'm especially delighted to be on this webinar with you today. Some of you on the call might be familiar with my name, as I've worked in and around staffing for the past 21+ years. I started out as a recruiter for a large national staffing firm here in Atlanta. Since that time, I've worked with companies like Bond Software, Bullhorn, and most recently at Aviante. As staffing firms, you have a few unique challenges around the completion of the Form I-9, especially when it comes to managing your remote candidates. I am very familiar with many of these challenges, so in as much as possible, I will address any of your questions that come in from that standpoint. On today's call, we are extremely pleased to introduce Attorney Rebecca Mancini as our key presenter this afternoon. Rebecca is currently an immigration attorney with Miller Canfield Law Firm, and she will provide an introduction of her background and skills momentarily. Also, please keep in mind that we will be sending out a follow-up email within the next 2 weeks, which will include a copy of this webinar, presentation, and also follow-up answers to all the questions that arise. Again, thank you so much for your time today, and at this time, I'd like to turn the call over to Rebecca.
Thank you so much, Melissa, for that introduction, and thank you to everybody for joining in on the call today. I, as Melissa mentioned, am an immigration attorney. I work for Miller Canfield Law Firm, which is headquartered in Detroit, Michigan. We have a global presence, however, and we're able to represent and support clients all over the world. My practice focuses primarily on complex corporate immigration and related employment matters, including, of course, related compliance issues, which we're going to be talking about today. As Melissa mentioned, completing I-9s and maintaining I-9s for a remote workforce, particularly for staffing companies, can be quite challenging. And today we're going to talk a little bit about some of the issues that come up for staffing companies, with a particular highlight on remote hiring considerations, and ensuring that compliance is met by employers to avoid fines and penalties and other issues that commonly come up. We have a little compliance roadmap here just as a reminder for all of you about the I-9 process in general. Even if you have a remote workforce, nobody has any exceptions from how the Form I-9 should be completed, whether your workforce is present in the office you're working in or whether they may be located hundreds of miles away. Regardless, each employee with your company must complete Section 1 of the Form I-9. The employer must also complete Section 2 of the Form I-9, and where necessary, Section 3 must also be completed by employer in the event of rehire or re-verification. Some key compliance requirements are noted at the bottom of the screen here. Just as a reminder, the employee must complete Section 1 on or before the first date of hire. Now, remote workers and other workers can have a Form I-9 completed before their first official start date. It's important to remember that the Form I-9 can be completed as early as when an employee has accepted their offer of employment. So in cases for remote hires where you may need to coordinate having an agent or representative help you complete the Form I-9, this is important to remember so that you are adhering to the strict 3-day rule. For Section 2, the employer or its agent or representative must examine original documents provided by the employee in order to complete Section 2, again, within 3 business days after the date of hire. The employee is attesting to his or her employment authorization by presenting the employer or its agent or representative with acceptable documents which evidence both their identity and their employment authorization for hire. Again, a reminder, there is no exception for remote hires. The Form I-9 must be completed the same for all employees. However, on the far right here, you'll see there is a staffing company exception, which states that an acceptance of an offer and entry into the assignment pool is considered equivalent to an offer and acceptance of employment for I-9 purposes. And therefore, staffing agencies may complete the full Form I-9 and create a case and e-verify at that time. In the sense of remote hiring for all employers, particularly in the case of staffing companies, which just have a higher incidence of remote hiring, we've outlined a few requirements which we know that it can be difficult to maintain compliance through when you're using paper-based Form I-9s to process your hiring of remote workers. Just a quick note, the average Form I-9 error rate is very high. 68% of Form I-9s are found to have some type of errors, mistakes, omissions that could lead to fines and penalties. You're not alone if you've got I-9s that need correction, or you're having a hard time as an employer in establishing policies and procedures which would help you reduce your error rates on I-9s and also to mitigate the risks of being assessed heavy fines or penalties. So it's important to keep these checklist points in mind when trying to keep down your error rates on I-9s and maintaining compliance. First, Section 2, again, as we've talked about, must be completed within those 3 first business days after the date that employment begins. The 3 days would be the absolute latest, and just as a reminder, the day that an employee accepted the offer of employment could be the first day that you can complete this. The person, either the employer representative or an authorized agent or representative of the company, must examine the documents in person and must be the same person who is signing and dating Section 2. The employee must be physically present with the examiner during the examination of the employee's documents, as noted above. And in terms of retention, the Forms I-9 must be retained for 3 years after the date you hire that employee, or 1 year after the date the employment terminates, whichever occurs later. And finally, all Forms I-9 and supporting documentation must be available for each employee within 3 days of an official notice of inspection. So we're going to talk a little bit more about notices of inspection and the process of that as we get through the webinar today. There are many remote hiring challenges specifically. We recognize, and Homeland Security has also been long aware of the issues that are associated with remote hiring of your workforce. In particular, we should make sure that authorized individuals, that includes those who work for the company, who are in typically a position within human resources, maybe the legal department, are properly trained to comply with all Form I-9 requirements. And in addition, if you are using agents or representatives of the company to assist with your remote hiring I-9 completion, that they are also properly trained and in a consistent manner with the company's policies and with the government-regulated compliance requirements. Specifically, employers may designate an authorized agent or representative to complete Section 2 on behalf of the company. It's very important that companies, employers, create a policy for choosing a remote agent. You would want to make sure that your policy clearly states the type of people who can act as your agent on behalf of the organization. Perhaps you have the same agent or agents in a certain area if your remote hiring is at a higher rate in certain areas, and it's somebody that you trust and who has been trained to follow through with not only general I-9 policies but also your internal policies, and to make sure that you're providing clear instructions to both your employees or your agents in terms of completing the I-9 remotely. Finally, you should implement a review process for all remotely completed I-9s to make sure that whoever is in charge ultimately back at the company and who is maintaining the records, that they're going through the agent or representative or other employee who has helped to complete the Section 2 of the Form I-9 to spot and correct issues that may have arisen in completing the Form I-9 Section 2, even Section 1 from the employee as well. USCIS does not require that authorized agents or representatives have specific qualifications. In fact, the Department of Homeland Security doesn't even specifically indicate who can or cannot serve as such an authorized representative on behalf of the company. Homeland Security does provide some examples of the types of representatives. They say agents, personnel officers, and they also indicate notaries. One thing that's very important to remember is that a notary public can act as an authorized agent or representative of the employer, but when they're completing a Form I-9, they're not acting in their notarial capacity. They are not serving as a notary, and they should not be placing their seal as a notary on the Form I-9, nor should they be signing it other than the section that is required for their signature on actual Section 2. Whichever agent or authorized representative is selected by an employer, they must carry out the full Form I-9 responsibilities on behalf of the employer. They must physically examine acceptable documents that were provided by the employee with the employee present, and they must also complete Section 2 by signing and dating it. However, even though they are responsible for completing the Form I-9 responsibilities, again, the employer is ultimately liable for any violation in terms of an omission, an error, or failure to complete on time a Form I-9, even when the form is completed by that agent. That is why it's of utmost importance to establish your policy for choosing remote agents, providing clear employee and agent instructions for completing the process, and implementing a review process back at the company for making sure that they have been completed properly. We talked about this briefly, but it's just very important to go over it again. The fact that Homeland Security and the I-9 handbook mention using notaries as agents and authorized representatives can cause quite a bit of confusion. In addition, notary means a lot of different things in different countries. So in the case that you are hiring foreign workers, they may be assuming that a notary is taking the place of perhaps an attorney, or that they need to take additional steps to put their stamp or seal or signature on the Form I-9 in their notarial capacity. However, again, they must make sure to not act as a notary public, just as an agent or representative of the company in completing Section 2 on behalf of the organization. There is a misconception, again, that they should sign and notarize, which is not accurate. And if the notary refuses to complete the Form I-9 by failure to provide a signature or failure to review the documents in person, then the employer must select a different representative. They cannot proceed with using that person. Anti-discrimination is another key component in completing I-9s. It comes in particularly important in terms of going back to establishing a policy and providing clear instructions for those who are completing Form I-9s, perhaps as agents on your behalf. It has recognized that the employment eligibility verification requirements and potential sanctions against employers for hiring undocumented workers may discourage some employers from hiring certain U.S. citizens and others to work in the U.S. In addition, employers may be misled or confused about what the proper procedures are for completing a Form I-9 and what the exact documentation is that's required or acceptable in order to prove your identity and work authorization in the U.S. We're going to get in a little bit now about audits and inspections and potential fines and penalties, just to drive home the importance of maintaining compliance with your I-9s across the board, and the importance of ensuring that it's done properly, particularly in the case of remote hiring, given that discrimination is something that is followed up on by various different government agencies who will be protecting employees against anti-discrimination. Anti-discrimination provisions of the Immigration and Nationality Act prohibit strictly four types of unlawful conduct. Number one, citizenship or immigration status discrimination. So discriminating in hiring practices against somebody who is from a different country, someone that you think is from a different country but you're actually not sure, and discriminating against somebody who perhaps holds an immigration status, such as a work authorized status like H-1B, L-1, or TN, for example. There's national origin discrimination as well. Again, it can be actual or perceived, just as in number one, so you could perceive that somebody has a different national origin and take adverse or retaliatory action towards that person in the hiring practices, which is strictly prohibited by the INA. Number three, document abuse during the Form I-9 process is also strictly prohibited and also strictly enforced as well. So making sure that you're collecting the proper documents, that you're not collecting too many documents, and that you're maintaining those copies of documents properly is very important as well. And finally, to avoid at all costs retaliation against employees in the anti-discrimination context is very, very important in order to remain compliant as an employer of workers. Now this slide just comes as a little bit of an overview of what we just talked about. So some key points of how you can overcome challenges in discrimination when completing the Form I-9. First, in the blue circle, employers may not demand specific documents from non-U.S. citizen workers. First of all, every worker should be treated the same in the I-9 process, hiring and onboarding, and to make sure that you're not demanding that certain classes of people, particularly non-U.S. citizens, are to provide documents other than what you're asking from U.S. citizen workers. So you should treat everybody the same and provide them the I-9 for completion and the list of acceptable documents, and allow them to provide you with the documents that they believe comply with what they need to show their identity and work authorization status. In addition, employers should avoid asking non-U.S. citizens and foreign-born citizens for more documents than is needed to complete the I-9. For many employers who have a primarily U.S. citizen-based workforce and may come across a foreign worker maybe for the first time, or there's somebody in human resources, for example, who is become in charge of the I-9 process, and they are not familiar with other types of documents on the list of acceptable A, B, and C documents, and they may just become confused and say, I need more documents. I actually need you to provide a social security number. I actually need you to provide a passport. This is something that needs to be completely avoided in the process in order to avoid discrimination on behalf of the company. So just keeping the policy the same, providing the list of acceptable documents, and allowing everybody equally to have a chance to provide the documents that they have available and they think meet the requirements is very important to have a policy of. You may not reject valid employment authorization documents from non-U.S. citizens. Non-U.S. citizens may be able to prove their work authorization in a variety of different ways, through maybe one document or a combination of documents. And just because they are not a U.S. citizen does not mean that the employer can reject valid work authorization. You need to accept it if it looks to be true on its face, it's valid, it meets the requirements for an A or B and C document, and that it appears to belong to that person, and that person appears to be who they are claiming their identity to be. And finally, it's very important that employers do not require that lawful permanent residents go through the re-verification process because their green card expires. This is a very common misconception. It's quite confusing because green cards have a 10-year shelf life. Green cards are good for 10 years, typically, in the ones that are being issued currently now. As long as an employee provides a valid green card at the time that they begin employment, then if they stay with that employer beyond the expiration date of their green card, they are not able to be re-verified. This is because permanent residency is a status that is granted as a benefit that does not go away regardless of whether that card is renewed or not. Because the truth is that those cards are not required to be renewed, and permanent residents may continue to receive the benefits of a permanent resident without having a card that is valid. If you are an employer who participates in the E-Verify program, this slide is particularly important for you. If you're not an employer that participates in E-Verify, then obviously you would not have to adhere to the requirements for E-Verify. However, the background is important to understand in the event you ever do switch to become an E-Verify employer, and just knowing what that would entail and what your additional requirements for compliance and avoiding discrimination would be. So first, terminating or suspending non-U.S. citizen workers for who you receive a tentative non-confirmation or otherwise interfere with the TNC resolution process can become a discriminatory process. So for those of you who are or may not be familiar, a tentative non-confirmation would be issued by Department of Homeland Security, USCIS, who runs the E-Verify program, if the documents that were input into a case in E-Verify came back and did not match. It could potentially be an issue with immigration documents, or it could be potentially an issue with Social Security documents, which would have to be handled with the Social Security Administration. Either way, an employee should be given the opportunity to resolve that or make a decision on how they're going to handle that before an employer makes a decision on how they're going to proceed with employment based on a TNC. Number two, employers may not use E-Verify as a pre-screening tool on a selective basis. So you can't try to run somebody through and make sure that they've got employment authorization before you offer employment. You know, you'd offer employment and then go through the process of doing, I-9 and E-Verify employment eligibility verification, as you need to within the 3 days after hire. It can't be done on a selective basis either. If you're using E-Verify, it's for all new hires after you have initiated use of the E-Verify program. You need to use, for using E-Verify to confirm continuing employment authorization of non-U.S. citizen workers who are not subject to re-verification is also problematic for employers using E-Verify. The use of E-Verify, if they're not they don't have a document that's expiring and they don't need to go through the re-verification process, then this is not a tool to be used to make sure that they still have employment authorization. Finally, requiring non-U.S. citizen workers to provide additional documentation establishing their employment authorization for E-Verify purposes would be over-documentation. You only need to collect what is required in order to go through the E-Verify process, and then also simultaneously what's required to complete the Form I-9 process, and again, leaving that up to the employee to provide those required and acceptable documents. We mentioned the E-Verify user manual at the bottom here. USCIS provides a great deal of information for E-Verify program users. The manual should be reviewed and adhered to. It should be part of creating and establishing a policy within your organization for maintaining compliance. And it's also updated regularly online. You should work with an attorney or representative who is familiar with the compliance requirements, but also the E-Verify hotline is a phone number that employers and employees can call in order to ask questions. It's a great, great resource if you're thinking about using E-Verify or you are using E-Verify and you have questions. So are you at risk as an employer of an ICE audit? Yes, of course, everybody is. And just for those who aren't familiar, ICE is Immigration and Customs Enforcement. It is another sub-agency of the Department of Homeland Security, and ICE has been granted, along with the other agencies that control immigration and compliance, a great deal of additional resources and funds to go into compliance and enforcement since the Trump administration took office. In fact, in April of this year, there was a concerted effort by all of the government agencies to issue statements indicating that they're going to be putting more efforts towards compliance in a variety of different contexts. Compliance in the hiring of foreign workers, maintaining wages of foreign workers, and then, of course, as we're talking about today, for maintaining I-9 records, which also go towards properly employing those, avoiding employing illegal workers as well, and maintaining proper records. So some key issues that we're going to touch on right now with regards to ICE audits. Number one, the integrity and record keeping of your I-9s is just as important as that for your tax records, for your general business records. It should be very high up there in terms of overall compliance as an employer of workers in the United States. When deciding who to prosecute or go after as a result of an ICE audit, defective I-9 forms are definitely a smoking gun for ICE. They're looking at everything on in your I-9 records. They're looking at whether you have forms for everybody, if you're missing forms for anybody, if there are omissions, errors of a substantive or technical variety. These are all going to be trigger points for fines and penalties down the road for employers. It's very important to note that if you receive an ICE notice of inspection, you're only going to have 3 business days to produce all of your I-9s. Those I-9s need to be provided within the 3-day period. An officer will typically always show up and say, I'm here now. You can waive that 3-day period if you'd like, and we can get this done now. Never do that. Always take the full 3 days, even if you've just completed an internal self-audit, even if you're very confident that all of your records are properly kept. It's very important to take the time to go through all of your documents again, typically with an outside the help of outside counsel, which is hired immediately to come in and look, or somebody who has a experience in compliance and can put a second eye on everything to make sure that you have the chance to collect everything that's proper, make any potential last-minute corrections that are necessary, and to be ready for that audit and inspection that's going to happen after the end of the 3 days. It's important not to destroy any documents, attachments, old forms I-9 that maybe you've held on to too long without purging after the required period, or any other company records once your notice of inspection is received. Yes, you can go through and do a self-audit, and perhaps if a signature was missing or you didn't have an I-9 for somebody and you could quickly do it within the 3 days, those are things that you can take steps to do, but you should not be destroying any records or you're destroying documents that you shouldn't have kept or anything like that. Those, unfortunately, once you're issued an inspection, unless anything was done in good faith in those 3 days, you should avoid taking any other steps to, for lack of a better word, cover up anything that may not be compliant. And again, we already recommended this, but it's very important to get somebody who is familiar with the process in to help you out in the event of an inspection. So how are penalties evaluated? This depends on a variety of different factors. That can be, the size of your business. How many employees do you have? If you're a large staffing company with a remote workforce, then obviously you would have more, potential incidences of errors. If you're a smaller company that's just getting started and perhaps you haven't had any violations before, then that could be taken into account as well. When I talked on the last slide about making sure you're doing self-audits and making corrections on your own, that really goes towards a good faith effort to comply. When you do complete self-audits, you want to make sure that you are documenting everything in a memo. That memo should go on top of your I-9 files so that an ICE officer can see that up front. It's going to say, I, Rebecca Mancini, am the HR manager at this company, and on this date, I conducted a self-audit. I found that these 2 employees did not have an I-9 on record, so we completed them. I found these 10 technical errors where we were missing the month for a birth date for this person. We were missing the date that this was signed for another person. And if you go through and do that, they're really going to like to see that on the top, that you're taking the steps to maintain proper records, and it will go a long way in terms of how penalties are assessed. So the seriousness of the violation is another factor that they'll consider in determining how they're going to assess your penalties. If you are a company that has committed I-9 violations in the past or has failed to correct I-9 violations in the past, has continued to knowingly employ illegal workers, and those are definitely on the higher end of the seriousness of violations. And then as you receive multiple offenses go down the line, first, second, third time beyond, you're going to get more serious penalties assigned to the company. Involvement of unauthorized workers, that goes to a little bit what I just said. If you are employing unauthorized workers, you're not accepting proper documents, you know that they're not proper documents, or you're not even completing I-9s, these can be more serious violations. And then again, if you're a multiple offender as an employer, this is also going to be problematic for you in terms of how they're going to assess penalties. So again, the penalties add up. It's very important to make sure that you're maintaining your compliance. You've got to produce Form I-9s and supporting documents if you've decided to keep supporting documents. You may choose to keep the supporting documents that you completed the Form I-9 with, or you may not. Either way, whatever a company decides goes back to creating your policy. Do we keep documents or don't we? You have to do it consistently throughout. So if you get an ICE notice of inspection and you produce your documents, and some employees have supporting documents and others don't, then that's not going to look good. If you made a decision on, January 1st of 2015, from now on we're going to keep documents, so everybody before that doesn't have them and everybody going forward does, as long as that's done consistently and memorialized in a memo in your documents, then that is a great way to make changes to your policy and implement them going forward. If you're found to have failed to re-verify using Section 3 for documents that had expired, then those are penalties that are substantive and can carry a higher weight than those that are technical. Completing your certification, so failing to sign, Section 2 is a very common mishap, which could carry a technical fine. Dates and signatures, again, technical fines, which are easy to miss, but really also easy to make sure that they're completed by just checking. Hiring unauthorized workers is a big problem. Engaging in document fraud, of course, employers need to avoid. We were already talking about your discriminatory practices. You'd want to make every effort possible to train everybody on what exactly those different types of discriminatory practices might be, how they may avoid being alleged to have participated in discriminatory practices is very important. And of course, you can't omit anything. The Form I-9 has to be fully completed. It cannot be partially completed. And you'd want to make sure that every single box that's needed to be completed on the sections that are completed on the form are done thoroughly. This chart is a great reference tool for the variety of fines, the range of fines. Of course, there's a minimum and a maximum, an average for everybody. And the minimums are still pretty high. I mean, it's per violation. So you miss one date or one signature, that's one violation. Then each time you're going through it, particularly if you have a large staffing company, if you've got people all over the place, I mean, these fines, you can see how quickly they could really add up. This is going all the way up to, multiple offenses where obviously they're getting higher. And then for non-technical, more substantive violations or knowing violations, obviously they're quite high. One thing that's important is that when they complete the inspection, so you get the notice of inspection, you provide all of your documents within 3 days, and the officer completes their inspection, they're going to provide you with a report of findings of the inspection. And with that, it's going to say what your potential fines are. You're going to be given the opportunity to fix the errors or omissions or problems that they have found that you're able to, but many you may not be able to fix. So you want to make sure that when you do get the opportunity to fix the ones you can, you want to do that because it would significantly mitigate the total of your potential fines and penalties that you'd be assessed. And then ultimately, after you have that, you'll have a judgment, so a final amount of fines. That is something you should definitely reach out to an attorney about because typically those are negotiable. So if you have a final amount, you may be able to further get that reduced, which could be even for large companies, significant amount of money. If they have the resources to pay it, they don't necessarily want to put funds towards these avoidable issues. But particularly for smaller companies, I mean, these can be significant amount of fines, which a company is not prepared or budgeted, to be able to pay. So definitely contact an attorney in these instances to make sure you fully mitigate your fines as best as you can. But the best practice is to of course, engage in proper I-9 completion and compliance from the very beginning. working with an experienced professionals who are familiar with compliance, at least until you have your policies, procedures up and running and smooth. And then, of course, using an electronic I-9 system is also a great way to do it, such as I-9 Advantage, which is monitoring your entire network of individuals, having everything somewhat automated, where it's helping you signal where you may have red flags, omissions, things completed improperly. These are all great ways to try to avoid fines and penalties for your company. So we've talked about most of these, but just generally a reminder of pitfalls of completing a Form I-9. The information has to be correct, of course. You review a document, you have to make sure it's completed properly. Pay attention to how the form is asking. So if they ask for the date to be in, day, month, year format, make sure it's completed in that format that's asked for. Make sure all check boxes are checked, signature boxes are signed, dates are dated. If you're keeping documents, you want to make sure that you keep documents for everybody, or you're not keeping them, don't keep them for anybody. Don't over document, don't keep too many documents if an employee provided you too many. Make sure that every employee on the payroll has a Form I-9, and perhaps those who are no longer on the payroll have it in the record within the required time period, perhaps after they left. And also making sure that re-verification is happening, setting up a reminder system, or perhaps using a software program like I-9 Advantage that's going to remind you when documents are expiring, and so that you have sufficient time to ensure that that employee doesn't go through a period where they're not eligible to work, or they haven't given the opportunity to provide documents timely to stay on payroll. And again, making sure that you're purging old I-9s according to the 1-year, 3-year rule, whichever is later. This is just a little bit of an idea of what employers can be facing in fines. Now, the one on the far right here, the largest I-9 related fine in history, was assessed to Infosys Limited, $34 million for I-9 fines. That company had a lot of other issues in terms of compliance as well, but it's just very important to see, like, these are really how high these fines can get. Other companies you'll see over on the left here, all of these fines are hefty, and they all come from a variety of different types of I-9 violations. So failing to complete forms timely, failure to have proper records on file, discrimination, unfair documentary practices, requiring green card holders to re-verify, and the list goes on. I mean, everything we've talked about in terms of compliance is really fair game in terms of issuing fines and penalties, and as we've seen from the chart of minimum and maximum fines and now this, it's quite easy for that number to really rack up. Internal self-audits. Again, these are the easiest way to avoid your company facing fines and penalties. You need to typically do this, as we suggest, on an annual basis. So at least once a year, somebody's sitting down and performing a self-audit and making sure that everything is up to snuff in terms of all the compliance considerations that we've been discussing on this webinar. If there's a change in personnel, meaning that perhaps somebody was the prior HR coordinator and was in control of the I-9 compliance, and that person has since left the company and somebody new started, that new person is always suggested to run a self-audit very close to the beginning of their employment to ensure that all of the records are proper, because that person that was, even you're not exempt as an employer from I-9 violations just because the prior person in charge made errors or omissions. You also want to start, we suggest, in the self-audit process by pulling a list of current employees hired after the I-9 requirements started, and to also maintain a list of employees terminated in the past 3 years to make sure not only do you have proper records on file for everybody that's currently on your payroll, but also that you're maintaining those records before they need to be purged for those who may have left the company. So just a quick overview. There's the 3 sections. You want to just make sure sections 1, 2, and then 3, if necessary, are completed all entirely properly. If there's anybody missing an I-9, you want to do that I-9. If there's any I-9s with any errors, you want to make sure that those are corrected. maintaining copies if you're deciding to do so, and then keeping a manual audit spreadsheet. So this also goes towards that, keeping a memo within your document so that it goes towards a good faith effort of maintaining proper compliance and good records. So just in general, best practices for overcoming your Form I-9 challenges, particularly in staffing. Audit your I-9s often and thoroughly, at least annually, perhaps more often if you're switching over control of who's maintaining those records. Implement internal training processes, so create your policy. Establish your policy, not only for I-9 completion in-house, but also for your agents and your authorized representatives. Establish clear instructions for those completing I-9s and for your authorized representatives, and implement a review process for all remotely completed I-9s as well. Use an electronic I-9 system, which will provide you with tracking, red flags if you have any errors, your audit trail, and additionally, it allows you to provide reporting, which will give you a very quick turnaround for your notice of inspection period as well. We touched on documenting your I-9 policy, but in addition to establishing how it's completed, you also need to make sure that policy establishes how your forms are maintained. How are you storing them? Are you using paper I-9s, using electronic storage as well? If you're using electronic storage and not through a software company, then you'd want to make sure that they are properly indexed and easily accessible as well, and also establishing your policy for purging I-9s once the 1 or 3 year rule is up. If you're using E-Verify, understand how it works and make sure everybody using it also understands how it works. Use it for all of your new hires once you implement E-Verify, and police your subcontractors when it comes to E-Verify as well. Copy documents for all is a best practice. We've mentioned throughout the presentation that it's your choice, and it truly is your choice how to go forward in deciding whether to keep documents or not keep them. We suggest it's a best practice to keep copies of those documents because in terms of self-auditing, if you have those documents on hand and perhaps an expiration date was missing, it's very easy to look at the documents and make self-corrections without having to do new forms and collect new documents. It's definitely a best practice in terms of making it easier on yourself as the employer to perform self-audits and make corrections where necessary. And then finally, keep your Forms I-9 separate from your personnel files. Again, these need to be available for inspection within the 3 days, and you don't want to have them mixed in with confidential documents relating to your employees as well.
Rebecca, thank you for such a detailed and informative presentation this morning. I am sure that all of our participants learned something new as it relates to the I-9 form. And in staffing, and the staffing market specifically, there are many challenges around remote hiring, and I'm sure that they also learned some valuable information there. This webinar, as everyone knows, is being presented by I-9 Advantage. I-9 Advantage is a full services provider of compliant electronic software, and there are 3 specific products that we offer. They're I-9 Advantage, I-9 Medic, and I-9 Remote. I-9 Advantage deals with those employees that you will be meeting with face-to-face. The employees will complete Section 1 of the form, either remotely or in your offices. And an internal recruiter on your end will meet with that employee face-to-face to complete Section 2. On the remote side, the employee will complete Section 1 remotely, and you can utilize one of the third-party agents that Rebecca mentioned on the call today to complete Section 2 on your behalf. The third product that we offer is I-9 Medic. I-9 Medic deals with your historic forms, and we can take all of your paper forms, scan, upload those forms, and we can even put those forms through an audit process so that you can then complete, correct, and remediate those forms. Again, we really appreciate everyone's time on the call today. And as a quick reminder, we will be sending out a copy of this presentation to everyone, along with any questions that came in during this webinar. Again, thank you for your time. Thank you, Rebecca, and have a great rest of the day.